We are seeing unprecedented convictions at the national stage with President Trump and Hunter Biden. These are going to have consequences for Second Amendment litigation. We thought it was probably a good idea to get a Second Amendment attorney's thoughts on it. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we've got some unprecedented things happening at the federal level with some consequences relating to the Second Amendment and the rights they're in. To talk about it, we wanted to get the perspective of a Second Amendment attorney. That attorney is from Michelle & Associates. That is Costas Moros. Costas, thank you for being with us today.
Thanks for having me on again, Kevin. Always a pleasure.
Absolutely. And guys, before we get into it today, as always, please like, share, and subscribe to these videos. Hit that little notification bell so that when we drop these videos, they go directly to you and you can be the first to see them. As always, we're trying to educate as much as we can so that when people are going to the ballot box in November, they can have the Second Amendment as a priority. So, Costas, let's just go ahead and jump right into this here. We saw the 34 felony convictions from the the New York State court on Donald Trump. Now, while we're not necessarily going to talk about that, a consequence that we've seen in the United States when having that label could be losing your Second Amendment rights. And now we're starting to see the mainstream media all over the place starting to report on the fact that New York is going to try to take Trump's CCW away. The reason why I find this interesting is that we just saw the case come out of the Ninth Circuit, the Duarte case that we talked about a couple of weeks ago, that basically had an opinion saying that nonviolent felons shouldn't lose their Second Amendment rights. Now, while New York isn't exactly in the Ninth Circuit, I'm just sort of curious, as a Second Amendment attorney, you're always viewing things at the state level, at the federal level. Do you see this as a potential beacon for 2A litigation to come? Do you see it potentially affecting existing litigation, specifically on CCWs that currently exist in front of the Supreme Court?
The short answer is no, but I'll explain why. So, first of all, yes, New York is not in the Ninth Circuit, so it won't be affected by Duarte, but it's in the Second Circuit, which is arguably one of the few that's actually worse than the Ninth Circuit in terms of gun rights. But the reason I don't see this one directly becoming a gun case is I just don't see former president, possible future president Donald Trump suing in court to get his Second Amendment rights back, because this is a person, whether he wins or loses, that has Secret Service protection for life. I don't think he really cares. And you never know with Donald Trump. Maybe he likes the showmanship aspect of such a lawsuit and he'd pursue it, but I really don't think that's what's going to happen. What it does give us is those of us arguing these sorts of cases, whether, actually running these cases through the system or doing amicus briefs, is it gives us a fun example to cite. So oftentimes when we're talking about whether former felons or current felons can have firearms, we talk about dangerousness, and we're just talking in hypotheticals, but this is a really good hypothetical. You could say in an argument, well, an example of a felon who's clearly not a violent threat is Donald Trump, right? No matter what you think about him, he's clearly not going to get his firearms back and go knock off a liquor store or do a mass shooting or do any sorts of these crazy crimes. He's not dangerous in that way. So the law, the felon prohibitor as applied to him is ridiculous. And we have Donald Trump might get some help here very quickly, because the Supreme Court is about to rule on Rahimi, which we'll have to wait and see, but it may end up deciding that dangerousness is the standard. So this whole, the NYPD and others are trying to make this big show of how they're going to revoke Donald Trump's CCW permit, which I frankly didn't even know he had still maintained that. But if he did and they're revoking it, they're clearly doing that for show. And that might be short-lived if the Supreme Court comes around and says that dangerousness is the standard. Now, even if they don't with Rahimi, they're holding another case called Range v. Garland, in which the Third Circuit set that standard, and Range won there, and the government's appealing. So even if they don't decide it with Rahimi, they will next year with Range. So I think that's what we can expect to see soon. It's certainly an interesting hypothetical to discuss.
I mean, he wouldn't be the only one waiting on Rahimi. Is there a time limit with which the Supreme Court has to actually give us an opinion on Rahimi? Because there's kind of, it's seemingly a lot riding on this, right? I mean, you've got a lot of cases in the Ninth Circuit that seem to be held up, the Duncan case in particular, and then ones that follow after that. Is there a set time limit for the Supreme Court, or is that just an expectation that we have at this point?
So the Supreme Court kind of makes its own rules. However, traditionally, they've always released all their opinions by the end of June. I can't remember if some years it's bled into the first couple days of July. I feel like I read that somewhere, but I don't recall for sure. But regardless, we should have an answer as early as tomorrow, but more likely by the end of June because they tend to release the high profile cases at the end. So Rahimi could happen anytime now, anytime in the next couple of weeks. It would be shocking if it didn't release by the end of June because that's when they always come out. So yeah, we should have some exciting stuff to talk about very soon.
I was going to say certainly something to look forward to there. Not just that, you know, we're kind of on SCOTUS watch for a few other cases to see if the Supreme Court decides whether or not they're going to take them for the next session as well. I guess concluding that, we saw something else that was kind of unprecedented in U.S. history. We did see an actual conviction on a gun crime happen with Hunter Biden recently. I think there were 3 charges. I was just curious, can you walk us through these charges and what it's actually stating that he did that was illegal?
Well, I want to first preface by saying I haven't followed the case closely, but my understanding, based on the news media, which is imperfect, is that Hunter Biden in 2018 was a user of crack cocaine. And we've seen that in pictures that have leaked and other stuff, so we know that's true. And at the time, he purchased a firearm, and he lied on the 4473, saying he wasn't a drug user, and he possessed the gun while being a drug user. I'm not sure what the specific 3 charges are, but that was the basic crime. So that's going on now at the same time as, there's all these challenges in the courts on whether the federal drug user gun possession prohibition is constitutional. So that the Hunter Biden case is arguably even more interesting than the Trump case. And that one's currently being litigated. So Hunter Biden could appeal and we could actually have a sort of Biden v. Biden court precedent. Now, personally, I think his father, after the election, which is soon enough that it would probably be before any appeals court ruling, I think his father's going to pardon him. I don't think he's going to leave his son out to dry just because, he's a dad. I almost understand and sympathize with that, despite what he's saying right now about not pardoning him. So he'll either pardon him or if there is a sentence, he'll commute the sentence. So I don't think we'll get a ruling, but it is interesting that at least in theory, you could have Biden appeal this and become one of the high profile challenges to the drug prohibitor in federal law.
Well, yeah, I guess let's hone in on the 4473 really quick. You know, it is illegal to lie on that federal form, the 4473 that you fill out when you're purchasing a firearm. I'm just sort of curious what your take is on this. You know, the firearms community has consistently kind of held this position that DOJ audits kind of open up the gate as a predatory tactic to finding mistakes on forms like the 4473 that could potentially fine or shut down FFLs. In your opinion, does this position still hold water while we also maintain the position that the law being enforced here is a just thing?
Well, I mean, the law being enforced here is a just thing because other people have been convicted of it, and it wouldn't be fair for the president's son to get special treatment. But that doesn't mean the law itself is actually just. And I think it really should be a sort of drug by drug, case by case basis. Now, what's interesting here is that, and I think if I recall correctly, Hunter Biden's legal team argued this, but what the 4473 asks is, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic, drug, or any other controlled substance? Hunter Biden, when he filled out that form, he argues that he wasn't a user of or addicted to. Maybe the timelines are close, but if he was clean for a week, maybe he thinks he can argue that he wasn't addicted to it, he wasn't a user of it, because the form is very vague on what a user is and what addicted is, right? So that's one huge problem with the 4473, and that's probably why lying on a 4473 to Hunter Biden's point, is not usually charged as a crime because it's kind of hard to prove unless it's one of the A or B ones, like are you a felon or not, and you lie about it, then that's an easy one. But so the drug one in particular is so vague and arguable that I think that's probably a problem with the form. And yeah, to your point, DOJ uses these sorts of gray areas. Both California DOJ and the US DOJ use these sort of gray areas to get gun stores in trouble and people in trouble, and that's a problem. Now, what's interesting here is that there's actually other cases, mostly centered around marijuana, which is not as hard of a drug as crack cocaine, as Hunter Biden is alleged to have been using. But those cases are currently pending in the circuits, and I think one is petitioned to the Supreme Court because there's a circuit split. So we could have a decision here in the next year or two from the Supreme Court on whether the drug prohibitor is constitutional, and if it is, whether it varies based on drugs, you know, because marijuana is less dangerous than crack cocaine, which is less dangerous than heroin. Sorry if I rambled a bit there, Kevin, as usual.
Well, no worries. I guess, these are a couple of things that I think are worth following along on. Obviously, this is on the federal level, not the state level. What is it? I guess, what are your final thoughts on these two things being so unprecedented as they are? And if we can bring it back to California, are there any potential consequences, good or bad, that you see from either of these things coming back to the state?
So it's kind of poetic almost that we have these two high profile convictions, one for President Trump and one for Hunter Biden, on issues that are currently pending. One's probably about to be decided by the Supreme Court, which is the dangerousness standard in Brahimi, and the other one is pending before the Supreme Court probably very soon with the drug prohibitor. And it's a crazy coincidence that we have these high profile examples of both of them. Now, I don't think these cases, there's a small chance Hunter Biden's case might actually matter in terms of litigation. I don't think Trump's going to file anything. So I don't think these cases will necessarily be decisive in one way or another, but I think they help the public understand how sort of silly gun laws can be, or at least start a discussion on them in Hunter Biden's case, because I think there is a respectable difference of opinion there on whether drug addiction and drug use should be a reason to prohibit someone from firearms. I think my personal view is it varies by drug, because addicts of certain drugs can actually be dangerous. Marijuana is not one of those drugs. Crack cocaine might be, but it's just kind of a funny coincidence that we had both of these happen right now, right as the Supreme Court is about to decide one of these issues and may decide another. So sometimes truth is stranger than fiction, I guess.
Yeah, well, certainly something to follow along with, and absolutely the consequences that we see back here in California to be watching out for. Costas, I know that you're a busy guy, so thank you very much for coming on and spending this time with us.
Thanks so much, Kevin. Always a pleasure.
Absolutely. And guys, if you like content like this, please, once again, like, share, and subscribe to these videos. Really helps us out with the algorithm and pushing this message out there. Thanks again, guys. We'll see you on the next one.